Hello friends, welcome back to Steno World. Now I am going to dictate legal matter at the rate of 100 WPM. So be ready for the dictation. 3, 2, 1, start. We have well considered the rival contentions. It is PW who went to president of the village club by leaving one person near the dead body. They both arranged the vehicle and then they came to the place of occurrence. When they reached there, it was found that he has expired. It is in the cross examination of PW that firstly he went to the house of president and that his house comes first when they entered the village and he told me to arrange one or two more persons from the village and in the meantime he got ready. We reached back at Dera in the midnight and 20/25 persons reached at the Dera almost simultaneously with us and that we had got made an announcement in village over Gurudwara loudspeaker and the police station is at a distance of 15/18 kilometers from our village and the Naka point is at a distance of 15/16 kilometers from the place of occurrence. These circumstances speak in themselves as to how the delay had crept in reporting the incident to the police. A fortiori, the alleged delay hardly dilute the effect of prosecution evidence. The delay is not fatal to the prosecution case. It is well settled that the delay in giving the FIR by itself cannot be a ground to doubt the prosecution case. Knowing the Indian conditions as they are, we cannot expect these villagers to rush to the police station immediately after the occurrence. Human nature as it is, the kith and kin who have witnessed the occurrence cannot be expected to act mechanically with all promptitude in giving the report to the police. At times, being grief stricken because of the calamity, it may not immediately occur to them that they should give a report. After all, it is but natural in these circumstances for them to take some time to go to the police station for giving the report. Of course, the Supreme Court as well as High Courts have pointed out that in cases arising out of acute factions, there is a tendency to implicate persons belonging to the opposite faction falsely. In order to avert the danger of convicting such innocent persons, the courts are cautioned to scrutinize the evidence of such interested witnesses with greater care and caution and separate grain from the chaff after subjecting the evidence to a closer scrutiny, and in doing so, the contents of the FIR will also have to be scrutinized carefully. However, unless there are indications of fabrication, the court cannot reject the prosecution version as given in the FIR and later substantiated by the evidence merely on the grounds of delay. These are all matters for appreciation and much depends on the facts and circumstances of each case. It has been held that merely because the FIR reached the magistrate after 3 days, its genuineness cannot be doubted. Further, it has been laid down by the apex court that the delay in sending the FIR may by itself not render the whole of the case of the prosecution as doubtful, but shall put the court on guard to find out as to whether the version as stated in the court was the same version as earlier reported in the FIR or was the result of deliberations involving some other persons who were actually not involved in the commission of the crime. Here, in this case, the version given in the court is not at variance with the one in the FIR. So the contention raised pales into insignificance.